Okay, right. I think people are largely joining us, and we'll make a soft start anyway, and I'll make the introductions. So you're all very welcome this morning, and thank you for joining us to another CEF and Selig webinar. My name is Mark Spence. I'm Managing Director of the CEF. My pleasure to welcome this morning Glen Watterson, who's a partner of corporate with Selig. Glen, you're very welcome. And as ever, we thank Selig. This is the latest in a long series of webinars that Selig are providing to CEF members throughout this year. We've already had a couple of very good webinars. This one promises to be very interesting. We've got very strong attendance today, which tells me it's something of interest. But also in the pipeline, we have webinars on project funding, fatal accidents at work, time-related claims, energy, and even drones, would you believe? So we've a full calendar of events. They're all available on the CEF website under events. So again, thank you very much to Selig. We very much appreciate your support as patrons to our members who I know make good use of your services as well. So Glen, I'm going to hand over to you this morning. You're doing our presentation on directors' duties and corporate governance. I would just say to those attending, we're very happy to take questions and answers. I think with a number of people attending this morning, the best way to do that is through the Q&A button, which you'll find at the bottom of your screen. Questions are anonymous, so you can submit any question you like. It'll be visible only to Glen and myself at the end, and we'll pick up those questions at the end of the session. So Glen, with no more ado, I'll hand over to you for your presentation. Thanks very much.
Thanks, Mark. Morning, everyone. Thank you very much to the Construction Employers Federation for having us and letting us sort of give the webinar on directors' duties and corporate governance, something that I suppose by looking at the attendee list is obviously on everybody's minds just at the moment with the way different sort of construction landscape and economy and everything is going. So may not be the most rock and roll thing for a Thursday morning, but we'll get through. Just wanted to, I suppose, give a bit of an introduction about Selig. Hopefully with the webinar series we're doing, everybody is aware of who we are, but we're a local and independent law firm, something we're sort of very proud about, the way that the legal community's been developing in Belfast. We're experts in all sorts of matters of corporate and commercial law. We give a sort of full in-house business law offering. And something we've adopted in the last number of years is a full 360 approach. So we can basically deal with all the needs of businesses, whatever sort of sector and industry that they're in. So just going to overview of what we're going to go through in the webinar today. I'm just going to start off by sort of saying, well, what is corporate governance? Why is good corporate governance important? We'll have a little bit of a look at the sort of structure of a company, the responsibilities and duties of directors, the issues and the risks that are going to arise for directors and sort of senior management of companies. Give some advices just around what to do and what the best practices are, and then look at some sort of potential future developments. So corporate governance it's a combination of rules or processes by which businesses operate, are regulated or controlled. The term encompasses sort of the internal and external factors that affect the interests of companies, shareholders, customers, suppliers, internal management, and all other stakeholders. Good corporate governance ensures that the board of directors meet regularly. They retain control of the business, have a clear idea and control over what's going on, and they're clear in the division of their responsibilities, as well as maintaining a system of risk management. It's basically the way in which the company and its senior management make decisions and carry out the executive function. Good corporate governance, it ensures that the board of directors cultivate a company culture of integrity, which leads to a positive performance, sustainable business overall. It exists to increase the accountability of all individuals and teams within your company, working to avoid mistakes before they can even occur. Really, the key objective here is eliminating risk and ensuring that the interests of the company are lived out through its board of directors. The importance of corporate governance is made apparent by positive impacts that occur when risks are controlled and organizational procedures are streamlined and consistent. Organizations can see many direct benefits with good corporate governance. Efficient processes due to repeatability and consistency of tasks are performed by the executive members. Visibility of errors. This is repeating and consistently having the same processes for decision making. That'll help identify where there's non-conformity in the decision making process and help eliminate the errors. Costs are reduced as well when tasks are streamlined, and companies can eliminate waste from the scrap, the rework, and any other costly inefficiencies. It also creates smoother running operations. Regular disruptions from inconsistent processes are eliminated as operations become either conformed or non-conformed. Now, apologies to any budding corporate lawyers out there for stating what may be obvious to you, but we're just going to overview what the sort of structure of a company is. So a company will act through two bodies of people, its shareholders and its directors. Shareholders of the company are effectively its financial supporters, its owners. Depending on the setup of the company, they can introduce equity finance and become owners of the company. Under companies legislation, certain decisions and actions can only be made with the consent of the shareholders, such as changing the Articles of Association, being the company's constitutional document, removing directors from office, changing its name, or entering into long-term director service contracts. In the absence of a good shareholders agreement, which I'm sure a lot of you either have or have heard about or have had a corporate lawyer selling you over the years, shareholders, they really have little power over the directors and how they run the company from day to day. The main role is to attend the meetings and discuss whatever's on the agenda, ensure that the directors in a general meeting, that the directors do not go beyond their powers and provide consent where it's required. The board of directors, on the other hand, they oversee the management of the company's business. They make the strategic and operational decisions of the company and are responsible for ensuring that the company meets its statutory obligations. Directors are effectively the agents of the company appointed by the shareholder to manage its day-to-day affairs. In Northern Ireland, and I suppose in our local market, a lot of the time the shareholders and the directors will be the same parties. So it's a little bit of an anomaly in that effect, but in the larger companies, that's what we're talking about in terms of those people being different groups. So we're going to the responsibilities of the directors, which really are very much set out in legislation, the Companies Act 2006. Now, I think there's maybe 5-6 slides of responsibilities of directors, so not to alarm anybody too much. A lot of these are things that are very much be in your focus from day to day anyway. The first director's duty is to act within your powers. So essentially that'll mean not acting outside what the company's constitution allows the company and its directors to do, and only to exercise powers for the purposes for which they were given. Company's constitution, as I touched on earlier, is really its Articles of Association and also any shareholders or joint venture agreements that have been entered into by its shareholders and the company. So really, if you are a director, you want to be making sure that from the outset of your appointment that you familiarize yourself with the company's constitution, with the articles, with the processes that are in there, with the decision-making powers and any sort of direct obligations you have to the shareholders in terms of decision-making. Secondly, the directors need to promote the interests of the company. That should really go without saying. They must act in a way that they consider to be in good faith, which would be most likely to promote the success of the company and all of its members being the shareholders. Success generally means long-term increase in value, but fundamentally it's up to each director to decide whether it's appropriate for the company to take a particular course of action, enter into certain contract, litigation, those sorts of things. The Companies Act and a lot of the comments around that distills what is the best success of the company into the list of matters that are on your screen there. So without, again, wanting anybody to get too intimidated by the list of these, it really is making sure that at the end of the day, you're considering the success of the company. An issue is not going to arise out of every decision that a director takes, but it's always sort of important to think long term and what are the effects of that decision. Directors must exercise independent judgment, make their own decisions. This does not prevent you from acting in accordance with the company's constitution if that's outside your sort of independent judgment, as long as it's an agreement the company's entered into in the normal course. Slide 4, and perhaps one of the most important duties, especially when I think of the sort of makeup of local companies, is for a director to avoid conflicts of interest. Directors must avoid a situation in which they have or could have an interest that conflicts or may conflict with the interest of the company. This applies in particular to the exploitation of any property or information, regardless of whether the company could take advantage of it. It's important to say that if you think you have a conflict of interest in a situation, you really need to be familiar with what is in primarily the Articles of Association. Their processes set out in each company's Article of Association, whether they be bespoke articles that have been created by the company's lawyer, or if it simply adopts what is sort of the statutory set of model articles. So usually that will mean seeking approval from the board of directors, or if they do not have the authority to authorize the conflict, then it's seeking consent from the shareholders as well. I think we missed one there. I'm just going to go back. Yeah, so really that fiduciary duty of exercising reasonable care, skill and diligence. Sorry, I passed that one. Directors must exercise the same care, skill and diligence that would be exercised by a reasonably diligent person. That's what the case law says. That is both an objective and a subjective sort of test. If you're a director, you're going to be measured against the general knowledge, skill and experience that may reasonably be expected of somebody carrying out that function of a director. But it's also measured against the general knowledge, skill and experience that you actually have as a director, that sort of subjective standard. So for instance, if you're sitting on the board of a company and you're an accountant, you're going to be laden with that sort of professional qualification experience you have from being an accountant, from being the person that should know what the financial position of a company is, rather than being somebody who's simply maybe in the more commercial side of the business and maybe won't have such an intricate knowledge. Moving down there to the sixth duty, which is not to accept benefits from third parties. Directors must not accept a benefit from a third party given to them because they're a director of a company. There's obviously varying degrees of what a benefit is, and this is sort of closely tied to the conflicts of interest point, so it doesn't, I suppose, sway your judgment as a director and custodian of the company. You'll be glad to hear that caseloads determine that receiving hospitality is not prohibited, and directors can receive benefits as long as accepting them wouldn't reasonably regarded to give rise to that conflict of interest. So essentially, come January each year, you'll not have to give back those bottles of whiskey and champagne that you received on the 24th of December. Directors have to declare their interest in any proposed or existing transactions. In the case of proposed transactions, you must do it as soon as you know that this is going to be a course of action that's going to be taken by the company, and any existing transaction you need to do that as soon as reasonably practical and when you know about the potential conflict arising. The duty won't be infringed if your interest has if your interest in the transaction cannot reasonably regarded as giving rise to a conflict, or the interest has been declared already because you're unaware that you had the interest. A properly convened board meeting is always going to commence with the chairman or whoever's leading the meeting sort of setting out what business is going to be transacted, and that's an opportunity for the directors to say if they're interested or potentially interested in the transactions that are going to be dealt with. There's some non-statutory duties you need to be aware of as a director as well. Duty of confidentiality to the company. You must use or disclose the company's confidential information only for the benefit of the company. So again, there's some crossover there with conflicts of interest which keep coming up, and also promoting the success of the company. There are also duties under health and safety legislation and duties to employees, and more recently environmental legislation and anti-corruption. So if we move on to the issues that can arise, corporate governance directly impacts the profits and the reputation of the company, and having poor policy can expose the company to sort of potential litigation and loss of income. Common sources of risks are, first of all, which again keep coming up, the conflicts of interest. When a director or another controlling member of the company has a financial interest that directly conflicts with the objectives of the company, for instance, if a board member has a significant shareholding in another entity that competes with or even has a trading relationship, a contractual relationship with the company in which they're a director, that conflict of interest is going to occur. As we've touched on before, conflicts of interest they're going to deteriorate relationships between the shareholders and the other stakeholders and the board of the company that's driving the direction of its business. And you need to make sure that where there is a potential conflict, that you either raise that with the board and have that discussed, get it ratified by the shareholders of the company, or take some legal advice if yourself as a director or the company are unsure whether there is a conflict. Oversight issues arise. So directors, as the people who are on the cusp of making the decisions, they have statutory obligations, and these are the people who are going to get judged if a company is successful or not. Directors need to have a substantial oversight of the company's procedures and practices. The board of directors need to ensure that where any level of management below them has the ability to make decisions or bind or commit the company to transactions, that level of management are controlled, or there's a substantial level of control over them by the board of director, and that any decisions being made or that are proposed to be made are to the awareness of the board. Oversight's a broad term that encompasses the executive staff reporting to the board, and the board need to be aware of the sort of daily operations of the company and the way in which objectives are being driven, being achieved. The board protects the interests of the shareholders, acting as a sort of check and balance, and that's why that sort of control function is something that needs to be set out in the board of any company, and making sure that they have the right processes down through the organisation. So accountability issues. Each level and division of the company should report or be reportable, or be accountable to another committee or section of the company, always culminating at the board level. It's a way of sort of having a checks and balances system, and making sure that above all else, the actions of each level of the company is accountable to the shareholders in the end, and the board need to have ultimate sort of sign off on all those decisions and functions are getting carried out. Without accountability, one division of the company might endanger the success of the entire company, or cause stockholders, shareholders to lose desire to continue in investment. The most important, I think, for the purposes of today's webinar, issues that arise, and something to make sure that everybody on the webinar that is director of a company is aware of, is the accounts violations. And essentially these are things that happen in in terms of the financial success of the company when a company isn't as profitable and it's starting to make losses and there's potential insolvency events. That this is an area where there is potential personal exposure for a director. If a company was to find itself in financial difficulties, what we would advise is, look, as soon as there is an onset of potential inability to pay any debts, any contractors, that sort of thing, the directors need to seek independent advice as soon as possible if they're to avoid a potential personal liability under insolvency legislation. The potential risk for director in this area, they're pretty complex, but ultimately where they end in worst case scenarios is a director's disqualification order, which could be sought by a liquidator or administrator of the company. It's an area where the duty to exercise the due care, skill, and diligence comes into effect, that fiduciary duty. It's very easy to demonstrate that when the company is doing very well financially. However, as I've said, when potential insolvency and difficult trading periods come into play, you need to make sure that the company's financial standing decisions they become a lot more difficult. Some of the key issues for a director, a company that's insolvent, post-insolvency are, as I've touched on, if it becomes a liquidation event, an administrator or receivers is going to be appointed over the business and assets and take control of the company. There's a modification of that general duty to promote the success of the company, and the insolvency legislation in this case brings in a duty to the company's creditors to ensure that, because insolvency is a likely event, that their objectives, that their needs are taken into account, and instead of acting for the success of the company, the benefit of its members who hold the shares and sharing the wealth, it's the company's creditors whose success is going to be an issue. Wrongful trading actions can be brought against directors by a liquidator, by another insolvency practitioner when they come in and take control of the company. These happen when the director, director or board of directors continue to make decisions, continue to incur debts, when that subjective test, that reasonably experienced director or somebody with the skills and qualifications of those directors continue to enter into contracts knowing probably full well that they knew, or they ought to have known, which is a very important consideration, that there's no reasonable prospect of the company avoiding an insolvent liquidation or administration. With wrongful trading, a director could be made to contribute towards the pool of assets that the liquidator is going to gather during its appointment. It's key to stress there, because we'll touch on fraudulent trading, but a director does not need to be dishonest or liable for wrongful trading, and he cannot avoid responsibility to resign from company when potential difficulties are spotted. It's a particularly thorny area for directors to navigate, and proper advice should always be sought. Then we've listed there also, I suppose, the next step on from wrongful trading is fraudulent trading. I know this isn't a insolvency webinar, but it's very important just that directors are aware of the risks on the line. With fraudulent trading, there needs to be a degree of dishonesty on the part of the director, or an intention to defraud the company's creditors, rather than with wrongful trading. It's just they should have known that this insolvency event is sort of more than likely, and perhaps they should stop incurring debt or enter into contracts that we're not going to be able to follow through on. They will come criminal proceedings, and at that level with fraudulent trading, you're looking at potential imprisonment penalties. Misfeasance it's not something that you come across very often. It's something the director can be guilty of if he or she is misapplied or retained company assets or wrongly exercised authority. It does not necessarily involve a moral blame. A director in breach of guilty of misfeasance may be ordered by court again to repay money or contribute to the company's assets, regardless if it's a winding up or a liquidation. Something that's more directed, I suppose, to the senior management, and that sort of non-board member, sort of executive level, is shadow directors and what's sometimes called de facto directors. As previously discussed, those appointed as directors of the company have certain statutory duties to abide by and they can be held liable, for any breaches of them. What you may not particularly be aware of is that if you are exercising that director function but not necessarily appointed as a director at company's house, you could be held to be a shadow director, effectively somebody who's not there on the face of the company, but they are really responsible for the decision making. They are making the decisions. They are stopping the legal directors, those appointed as directors, from making decisions. And in that scenario, it's those people also who will be on the hook if anything happens to the company. So if you are really part and parcel of the decision making process and any of these key decisions you are a party to, there is a potential that you will be held out to be a shadow director and be subject to exactly the same standards, as your de facto, as your legal directors. So we're going to look sort of advices now and sort of steps to follow and what you should be thinking about in your day-to-day role. Not that you have enough on your plate already, but think about the success of the company and the business that you're involved in. Articles of association. So really one of the steps followed is to, one, I suppose, if you are a shareholder of the company, a shareholding director, it's to make sure that you take the proper legal advice and you get a good set of articles drafted and adopted by the company. Secondly, also, and we'll touch this as we go down, is you need to familiarize yourself with the Articles of Association. If you're not a shareholder, but you are a director, you need to know what the processes, the decision-making processes, the record-keeping process, and everything that the articles deal with and cover. Most of you probably should know what the Articles of Association are, but they're that constitutional document together with shareholders agreements and things. They are sort of the rule book of the company, and they're filed at company's house, so anybody can go on the company's house and look at your company's articles. Issues that are covered off in the articles are typically with shares, the rights that attach to the shares, kind of shareholder transfer their shares. Are there any sort of drag along provisions where you can, a certain amount of shareholders can drag the rest of the shareholders into a sale? That's not particularly important for the purposes of the webinar. For people who are just directors, but it's more the decision-making processes that are set out there, the board meetings and what the sort of process is, how a board meeting is called, what the quorum is, who needs to be there, and how decisions are made. Is it a majority? Is it a unanimity? It's something you really should familiarize yourself with. Another point, just finishing off from the articles, is, and this is an advice, is a record keeping. When it comes to potentially being on the hook for making decisions or not making decisions in the face of insolvency, record keeping is very important. You should ensure that minutes are taken of all meetings. And now, if I had a point for every time you'd ask a client for maybe either the history of their board meetings and other decision-making records, that they don't have any, or they never do it, or all they have is what the lawyer provided to them when they were doing some sort of share transaction, you have to be a very rich man. But it's something that really should be done, and colleagues in England, Wales, across on the mainland, the UK, it's always a lot better than it is here, and I think it's something that we just need to learn in the corporate community, is that you're doing that for your own benefit, even though time may be tight. Shareholder agreements, which I mentioned, again, shareholder agreements are very important. If you are a shareholder, particularly you're a shareholding director, you really want to have shareholder agreements where you have more than one shareholder in the business. It's a private contract. It doesn't get registered at company's house. It's entered into between all the shareholders in the company and usually the company itself, to ensure that the company is bound and the directors of the company have to act in accordance with what it has. If you're a director of a company but not a shareholder, so you may not have seen the shareholders agreement, it's important to have sight of that. It's important to know what the decision-making powers are, where the shareholders have to have a veto or have to consent to certain transactions to be made. That is something just that it would be important down the line if there is insolvency events, if something does happen in wrongful trading where it can be shown that somebody had a higher degree of control because of the contract and you had to act in accordance with that agreement. Together with the Articles of Association, the company, Shareholders Agreement, and the Companies Act, if applicable, shareholders will say this will form the rules and requirements by which the company, its directors and shareholders are required to act in relation to each of the company itself. What's in a shareholders agreement? So we've listed some of the key processes there. It's appointing and terminating directors. Again, that's going to be important for you to know in terms of what a board can do in changing its constitution, who makes it up, how decisions are made, as I spoke about, in potential vetoes, restrictions on transfers of shares, restrictive covenants for shareholders, not that important for directors, and dividend policies. Obviously, the shareholders are the people who benefit from the dividends. They're receiving the dividends, but it is the company in the normal course, depending on what's the shareholders agreement, the board of directors that will be declaring those and considering what amount of dividends is going to be declared. Another advice and steps following is surround yourself with the rights for professional advisors, the right to professionally qualified people when you're carrying out your business. It's not every company where the members of the board, have all the necessary training, necessary skills or experience that covers off all the areas of risk. Some large companies will have a director who's a lawyer. A lot of companies will have a director who's a chartered accountant. But we would sort of say, firstly, have a good range of professionally qualified board members where you can that have those necessary skills and are able to step to the front when certain issues occur, deal with HR issues if you need an HR certified board member. It just means that different risks, different issues arise, the risk around them can be avoided with the right decision maker and the right people. In the absence of that, you can circumvent a lot of problems by ensuring that you take all the proper advice and take it in good time, not to go run to the accountant or the lawyer or the insurer whenever it's too late. It's to make sure that potential areas of risk issues are sort of headed off at the pass. You mentioned directors and officer insurance here. That is one where it's very, with any insurance policy, yes, it's difficult to know exactly it's going to be covered, but we're seeing a real increase in clients, directors and officers of companies in all jurisdictions taking out director and officer insurance, and they cover liability for directors for certain decisions if things happen. So it's another way. Obviously, fraud and dishonesty and those sort of matters are excluded, but it's another way of sort of limiting your personal risk through to the sort of wrongful trade and the insolvency events that may arise. And just on service agreements, again, it's always very important to have a proper contract of employment for a director, setting out what the director's obligations are to the company, who they report to, and it's for the protection of both the director and the employer and the company he serves, just to make sure if you're in breach of any judicial obligations, it's very clear in writing what they are. Just going to touch on potential developments and things that might change the landscape as we go forward. GDPR is one that I've been talking about a lot, and it's not going to be a data protection webinar, but we all know that GDPR came in, I suppose it's 3 years ago now, and despite Brexit, we're still bound by the terms of GDPR. the importance with GDPR and the 2018 Data Protection Act in the UK is that it puts a lot of obligations onto the company. It sort of adds in those other duties that are outside the director needs to be aware of, the sort of not the bribery and corruption acts and things like that don't sit in the Companies Act. There's added obligations for a company to make sure they have rigorous, security systems in place, and that usually one of the board or one of the executive key senior employees is appointed as a data protection officer. There's more than likely going to be more shake-up in this just following Brexit and the UK's sort of aim to try and simplify the legislation, try and reduce those burdens on data controllers and data processors. But it's one to keep an eye on, and we've an article out there at the minute just sort of updating clients on what the developments are likely to be. So it's something to keep an eye on, and also make yourself aware of, and take the proper professional advice, be it from a lawyer, or we're seeing a lot of sort of consultants that are doing the sort of GDPR market now because of these obligations and potential areas of risk that are there for a company. Corporate and social responsibility, it's this with I suppose the green world and recycling everything is just the carbon emissions. It's the buzzwords at the moment. There's definitely going to be in the next couple of years sort of shake up and introducing different obligations for companies in relation to making sure that they reduce carbon, that they're in line with all these sort of softer sides of what I suppose society is putting into the business world at the minute. As I've said, businesses have become focused on aligning their own interests with this, and have subsequently been ramping up the focus on these issues, whether it's championing women's rights, protecting the environment, or attempting to obliterate property on local and national levels. Being a socially responsible company, it's going to bolster the company's image and build its brand, empower the employees, and leverage for corporate success at the disposal of the company. Having formal CSR programs can boost the employees' morale and can lead to greater productivity in the workforce. But we also foresee, on the next slide, we also are foreseeing there's been sort of papers going through Westminster where there may become an obligation for companies by amending that duties of directors and sort of to act in the best interest in the company, all that to introduce a sort of greener, softer side to that. The draft Better Business Act, it proposes sort of changes the focus of the director's duty from being to promote the success of the company to being sort of to advance the purpose of the company, sort of to try and create a bit of grey area around that success and financial success to more of the success of the company and the environment and the society in which it operates. Set out there. Set out there that the four principles that are involved in that are ensuring the interests of shareholders are advanced alongside the wider society and environment, empowering directors to exercise judgment in weighing up and advancing the interests of all stakeholders rather than just the members and the shareholders. The default change is going to apply to all companies rather than just public limited companies or different sectors. And it's going to require business to report in a sort of annual report, annual accounts, how they balance people, planet, and profit in a strategic impact report. I've got money laundering up on the slides there. That's one I know as ourselves as lawyers and being subject to pretty strict money laundering regulation. This is something that's starting to creep into the wider business world, wider range of companies, and it's definitely something to be kept an eye on. Again, there'll be external consultants and professional advisors who are going to become experts in advising companies what they need to do and what information they need to get, be that proof of funds, bank statements, and all sorts of ID of the directors of different companies that they're dealing with. It's something that's added a fair workload to our days as solicitors, and it's something to stay on top of, because again, like data protection, the fines that they're talking about in different commentary, it's going to be pretty material for companies. I suppose that's the end of what I had wanted to cover. So hopefully when we log out to the questions here, there's a few questions from everybody, and I hope it's been informative as well. And thank you for our time this morning, and Mark and CEF for having us.
Thanks very much. That's very comprehensive. A couple of things there just to get the ball rolling, if you like. From my point of view, I'm interested in the de facto director, shadow director definition, and how that sits with non-exec directors. I would be aware a lot of construction companies, will have their sitting board and often family members, but may bring in non-exec directors who may not be a permanent role. It may be for a specific purpose, bringing in some expertise. So how do those individuals, I suppose, protect themselves in that sense from being actually a director of a company, if there's anything to be wary of?
I suppose with the non-exec directors, Mark, we would be very much seeing them as directors, as being subject to those list of statutory duties and the other sort of duties that flow around that. As a non-exec director, if I'm coming into an organization to sit on its board, to help it make decisions, to maybe exercise a bit of a legal function for them, I'd be saying, look, I need directors and officer insurance in place here, because you're probably getting a daily rate or an hourly rate for sitting at board meetings. You've only access, I know you should be requesting access to everything, but you maybe only get access to certain information, certain divisions of the business that you're maybe giving them advice on. So you would want to have proper D&O insurance in place, if in case you got on the hook for sitting over a separate part of the business you actually haven't been making decisions on, to cover any sort of potential personal liability there. But another objective is just to make sure that there's a proper appointment letter that sets out exactly what your role is, what you're going to advise on, what areas of business you're working on, and that's something that you can step back to and sort of show anything down the line if any issues do arise. Look, I was only advising in these areas, and it shows your sort of limited liability. If a insolvency practitioner was to come in and look at a company that was, had gone to the wall, and it was because certain decisions were made in another area of the business, you're attending board meetings every so often, you're adding your judgment in, it's going to be unlikely that you've made a large decision in terms of incurring different debts or entering into risky, you're going to be that impartial voice. So the chances, I suppose, off the record, the chance of you getting made personally liable compared to the executive members of the business is going to be a lot less, but you really do need to make sure you have the proper contract, and you also, ask the company to put insurance in place for you.
Okay, and then I see we have a question, not unrelated to that, a bit similar to that, but asking, is there a difference in responsibility of a non-statutory director? In other words, somebody could be the director of a function in the business, as opposed to being a statutory director who is named at the company house. I suppose that's quite a common feature. A lot of companies would have a lot of people who carry the title of director but may not be a statutory director.
Yeah, and look, we would advise some clients on this in terms of making it clear in email footers or any other sort of company stationery that you're not a director in terms of a board, company's house registered director. A lot of accountancy firms will have executive director or managed director, junior director, things like this. That's very common, but you're not subject to those duties and obligations unless you are an actual director of the company. Now, if you're called a director and for all intents and purposes you make a lot of decisions but aren't registered at the company's house, you could still be held to be a shadow director if you're carrying out that director function, binding the company, committing it to different contracts. Mm-hmm. So just make sure if you are a director that it's clear in the email footers and those things, legal director or not a legal director. So you're not registered company's house and all that sort of stuff.
If you had your way, Glen, would you advise companies not to give the title director freely? does it cause confusion to do that?
It does. I think it does, Mark, and I would try to steer away from it, because you're sending out that message that you are a director, that you are the person who's going to make decisions in accordance with Companies Act.
Yeah. Okay,
make it clear if you've got your contracts, make it clear. You can make it clear in sort of schedules who the directors are and who's got the ability to sign off on contracts. Because if you enter into a contract with a third party and someone who's not a board director signs it, they don't have the ability to bind the company. But case law says that if you've held yourself out to be able to bind the company by signing contracts and by negotiating contracts, the third party, that they're covered. That contract will be binding because they've taken you as a sort of a face value.
No, that's a really important point. Another question coming in: are there any distinctions between duties under an SPC?
Can't see that question mark.
It's coming under the chat there. I'm assuming SPC, we're talking special purpose company. Does it have any distinctive?
No distinctions. Nothing different. Company's company for all intents and purposes in the Companies Act. The only distinctions are public and private. But yes, I don't think we've any public limited company directors probably on today. But no, that's something to be happy enough to chat through offline, because they're quite intricate.
And a question again, this is a recurring theme. How would anybody from the outside establish when a person is a shadow director? So, for example, if they're not recorded in the director's minutes, or they're not highly visible in the company, but they clearly have an influence in the background, how objectively would it be established that they're a shadow director?
Look, I would say if you're approaching a company and somebody is, how would anybody who's an outsider establish? It's not for an outsider to establish that. It's for the concern is for the individual themselves. If you're really, say you're a shareholder and you run that company, but you don't want to be seen to be on the board, but you're the person in the background making all the decisions, you're going to be a shadow director. There's absolutely no doubt about that. The level below is to say you are a senior employee, but you're making lots of decisions. That's where you've got to be careful. You've got to be conscious, because that's not your intention to be a director, until you are on the board of directors. As an outsider, as somebody from another company, if you're entering into a contract and somebody's, as I said, signing a contract, but they're not on Companies House as director, you have to take them as sort of bona fide third person. You have good faith that they're able to bind the company because they're signing contracts. If you're in any doubt as an outsider as well, you check Companies House, see who the directors are, see who the people who can sign contracts. But the test isn't a black and white one of, if you do this, you're a shadow director. If you don't do that, you're not. It is if you are carrying out that executive function, carrying out those decisions, making those decisions, responsible for those decisions, you're more than likely not to be held to be a shadow director. The shadow director really comes up where you have those insolvency events and the different people that can be captured. We've had instances in the past acting for insolvency practitioners where companies have become insolvent and the insolvency practitioners going after somebody who's not a director, because everybody knows in the background that they've been making decisions. So it's a way of sort of, you need to document who you are, your directors, and like, don't think you can hide behind it by not registering yourself.
Okay, that's great. Just thinking as well about wrongful trading, and I know this is an age-old issue, and construction companies are particularly aware of it. So if a contract is turning bad and it's of such a scale it could impact the business, I suppose it's more of an art than a science. Is it determining at which point you are wrongfully trading? I suppose everybody trades for the next quarter and the next set of accounts, and it's the next tender that will get us back on track.
Yeah,
the line in the sand somewhere there where you've gone beyond where you're trading successfully and you're potentially wrongfully trading. It's quite a hard one to define.
It is, Mark, and it's not an exact science, and I touched on it in the slides. It is, look, take that advice. You'll know as a director of company, from your experiences, when things are tight, when potentially you'll have doubt whether you should be entering into a contract, going for another contract, if it's going to cost you more money than you're going to make in the end. Are you going to be able to pay in advance for your employees or your materials as a construction company? the best thing to do is get not so much an IP, but it would be to get an insolvency lawyer on board as early as possible, just to give you that advice and look through things, particularly with your financial controller or finance director.
Okay, and just to be clear, Glen, are you wrongfully trading if you knowingly sign up to a contract where you believe you'll lose money, but it may be a strategic contract for you, provided it's not of a scale that would tip the business, obviously?
No, you're not. If you're taking that decision in the best interest of the company because you think if I enter this contract, it's going to open a lot of doors for us, it's going to make us profitable in another sort of side business or whatever the case may be, Mark. If there are reasons for doing it that are in the best interest of the company, you're adhering to that duty. It's really when you see things starting to go south and that potential benefit on the side isn't there anymore, that's when really you need to start thinking about it and taking the advice.
Yeah, no, I think that's really key, and I'd be conscious a lot of companies are sitting in boardrooms at the moment deciding whether to sign contracts, and obviously with the materials issue, that's hugely impacting the profitability of a particular contract, but it might still be the right thing to do for the longer term. So that's interesting to get that.
Yeah, absolutely.
We've no more questions, so I have one more question, but if anybody wants to type in a quick question, we'll certainly take it before we finish. But if not, I was just going to touch on then the sort of the themes, I suppose, are changing all the time. It's interesting to see societal and environmental aspects coming into the director's duties now and the responsibilities broadening. And again, I suppose that's an area where not everybody's an expert. So is that a case of directors having to equip themselves with this expertise or outsource it to make sure that they are meeting those newer, if you like, expectations of their role?
Yeah, and especially on the sort of environment, the carbon side, Mark, it's such a fast moving area at the minute. And I think when we have the COP conference in Glasgow next month, we're just going to see acceleration in that. And I saw Boris Johnson yesterday really throwing his weight in behind the green movement, the low carbon movement, and all of that, and adding support. So these types of potential reforms to legislation that they're going to come through, and they're going to come through pretty quickly. Again, this has been in the making for a little while. What it'll mean on day one, I don't think it'll mean a great deal for a company in Northern Ireland, a small medium enterprise, but it'll just be interesting to see what is in that legislation, because there could be incentives or fines or things like that, or potential liabilities, and that's when really I think we'll need to review the wording. Clients need to come and see us, and we'll just sort of discuss through what actions need to be taken.
Very good. We do indeed have a quick final question then that's come in. Can a director of a subsidiary board be overruled by a holding board or by a shareholder in decision making?
There's a lot of depends in this question, but really it depends on the constitution of the company and whether shareholders have vetoes over the decision that's been made, the area of it. So you'll get a lot of shareholders agreement that'll put shareholder consent required for certain decisions, be big decisions or be decisions around dividends, things like that. So they can have a veto. Yeah.
Okay, that's great. Okay, there are no other questions at the minute, Glen. So I'm just going to wrap up and say thank you very much for a very comprehensive presentation. We have recorded the session, and we will make this available to those who've registered, and we'll send those details out. And just to say that the next Bill Selig webinar is on the 21st of October and is funding for projects. So again, go to the CEF website and get registered for that one. But Glen, thank you very much for your support today. Thanks, Bill Selig, as always, for being our legal patrons. And thanks everybody for taking the time out this morning. Hope you find it useful. And look forward to seeing you at the next one. Thanks very much.